Here's another topic I'd like you to know for the Department of Real Estate's exam. Truth in Lending Act, Regulation Z, and other acts. The purpose of the Federal Truth in Lending Act is for the lender to disclose the cost of credit terms to the borrower. Remember that this disclosure must be presented to the borrower within 3 business days of receiving the borrower's loan application. Regulation Z applies to dwellings with only 1 to 4 residential units. Agricultural loans are exempt from the Truth in Lending law, as are businesses and commercial loans. The Truth in Lending Act is known as Regulation Z. Now, Regulation Z also states that the lender must express all related finance costs as a percentage, known as the annual percentage rate. Regulation Z requires creditors to make some important financial disclosures, and these are spelled out for you in the reading. But the 2 most important items, according to Regulation Z, are the APR and the amount financed. Now, to clarify here, the APR is the cost of credit. Now, this is expressed in terms of percentage. It is a percentage rate, not an interest rate. Now, if the APR appears in an advertisement, no other disclosure of terms need to be stated because it includes all the credit costs. You may also be tested on what APR does not include. It does not include cost of a credit report or appraisal fees. It is also important to know that the borrower has the right to rescind when a loan is secured by a second trust deed on an owner-occupied single-family residence. I also want you to know that the borrower has the right to cancel. The federal law gives the borrower the right to rescind, cancel, any loan transaction only if it is a business loan or second trust deed secured by the borrower's home. The borrower has until midnight of the 3rd business day following the signing to cancel. These only apply to loans subsequent. A first trust deed loan to finance the purchase of a borrower's home carries no right of rescission. Also on the topic of borrower rights, we have the Equal Credit Opportunity Act. This is a federal law prohibiting those who lend money from discriminating against borrowers based on their race, sex, color, religion, natural origin, or marital status. Now let's take a look at our ever-changing economy. First, let's talk about inflation. When prices appreciate, this protects both the lender and the trustor. The home holds more equity, protecting the lender if there is a default. To understand the general level of prices, when prices decrease, the value of money increases. When the prices increase, the value of money decreases. When you have to buy gas for $2 a gallon, the value of your money increases compared to if you had to purchase that same gallon of gas for $3 a gallon. The value of your money has now decreased. Who controls the flow of money in our economy? The Federal Reserve Banking System does, or otherwise known as the Fed. Now, the Federal Reserve Board, that's a committee that's appointed by the president, but politically independent, that regulates the amount and flow of money available to banks. The Federal Reserve's monetary policies influence the supply of money. They do so by buying and selling government T-bonds and securities. They also do this by raising and lowering the reserve requirements and discount rates to member banks. They also establish and set margin requirements. This is the percentage loaned on stocks and bonds. In studying our economy, you also hear about the gross domestic product, the GDP. Now, this is the total value of all goods and services produced by an economy during a specific period of time. It serves as kind of a monetary barometer that shows us the rate and area of greatest growth. Now, if you live in one of these areas of growth, you're probably going to be looking to buy a home. Most people looking to buy a home are going to borrow the money. And this is the largest financial obligation this person is likely to assume. The 3 areas of demand for borrowing money are construction funds, financing a purchase, and refinancing. So where does this money come from? You can either find money from an institutional lender or a non-institutional lender. Let's look at the institutional lenders. These are very large corporations that lend the money to their depositors to finance real estate transactions. Institutional lenders are big lenders. They pool money together so that they can lend to individual borrowers. These include insurance companies, savings banks, and mutual savings banks. The Federal Deposit Insurance Corporation, FDIC, is a government corporation that, for a fee, insures each account of a depositor up to $100,000. Savings banks are the greatest source of money for home loans. They make more real estate loans than any other financial institution. They primarily make loans on single-family homes or condos that are owner-occupied. Occasionally, they will also make loans on apartment buildings and manufactured homes. Your corner banks are general-purpose lenders, which means they lend money for anything from real estate to cars to recreational vehicles. All national banks are required to be members of the Federal Reserve System, while a state bank may be a member by choice. In general, there are 4 types of real estate financing. There is your first trust deed loan, a construction loan, or what's also called an interim loan. This is money provided for the construction of a building, which is to be repaid when the construction is completed. Notice that a construction loan is considered a short-term loan. There's also the takeout loan. This replaces the interim loans. This is money arranged by the owner, builder, or developer for the buyer. The construction loan made for the construction of the improvements is usually paid in full from the proceeds of this more permanent loan. And then we have the home improvement loan. Obviously, this loan is for making repairs and modernization of existing buildings. A primary source for a very large loan would be a life insurance company. These companies supply most of the loan funds for properties where a great deal of capital is required. Things such as high-rise office buildings, industrial properties, or hotels. Life insurance companies seldom make construction loans. Now let's go over to non-institutional lenders. These are smaller lenders, which include private lenders, mortgage companies, investment trusts, pension plans, and credit unions. Unlike institutional lenders, they are not governed by the Federal Reserve System. Most private lenders tend to be individuals who are sellers, who take back a second trust deed as part of the real estate transaction. A credit union is a cooperative association organized to promote thrift among its members and provide them with a source of credit. Another non-institutional lender that you might be tested about is the Real Estate Investment Trust, or REIT. This is a type of company that sells securities specializing in real estate ventures. Remember that a real estate investment trust requires a minimum of 100 investors. These companies will either invest in real estate itself or several real estate projects, or they will invest in the mortgages and other types of real estate loans. I will soon go into detail about the secondary mortgage market. This is a resale marketplace where smaller lenders sell their loans to the larger lenders. Mortgage companies like to make loans that can be sold easily on the secondary mortgage market. Note the term warehousing. This is the action of a mortgage banker collecting loans prior to the sale. Now you've probably heard of the term VHA or VA loans. These are government-backed loans. Unlike conventional lenders, the Federal Housing Administration and the Veterans Administration approve loans made by private lenders, but they do not lend money. You also want to remember that the Federal Housing Administration is a division of HUD, Housing and Urban Development. The FHA has 3 main programs that affect California homeowners and buyers. First is Title I, Home Improvement Loans. The FHA insures lending institutions against loss on loans made to finance improvements on existing structures. FHA Title II is for home purchases or building loans. And then we have Title III. The Federal National Mortgage Association, Fannie Mae, buys and sells loans. In the next section, I'll discuss in a little bit more detail the Federal National Mortgage Association, otherwise known as Fannie Mae. Now, when assisting a home buyer in obtaining an FHA loan, a broker would most likely contact an institutional lender. Now we have VA loans, guaranteed loans. The Congress of the United States has passed legislation to assist veterans in obtaining housing. A VA loan is not a loan, but rather a guarantee to an approved institutional lender. Some of the provisions of a VA loan requires no down payment, but may require that the veteran pay an origination fee up to 3% of the loan amount. In addition, the seller may have to pay discount points. Now, while we're on this topic, I'm going to bring up the California Department of Veterans Affairs, otherwise known as CalVet. Land contracts are used, and legal title is held by the California Department of Veteran Affairs until the loan is paid in full. So here I'll clear up the topic about the lending corporations and the secondary market. The secondary mortgage market is a market where lenders buy and sell mortgages. The secondary mortgage market is the transfer of mortgages among mortgagees. This allows lender more capital to continue lending. Now let's get back to Fannie Mae. Fannie Mae dominates the secondary mortgage market. It sells securities over the stock exchange to get money so that it can buy and sell conventional loans, besides government-backed notes. Fannie Mae is not a demand source to borrow money. Fannie Mae was created to increase the amount of funds available to finance housing. I want you to remember that liquidity and marketability is a major concern for lenders in the secondary mortgage market. The secondary mortgage market enables lenders to keep an adequate supply of money for new loans by selling off their current loans at a discount rate into the secondary mortgage. Now, there are three major players in the secondary market. These are the Federal National Mortgage Association, Fannie Mae, the Government National Mortgage Association, Ginnie Mae, and the Federal Home Loan Mortgage Corporation, Freddie Mac. Let's look at Fannie Mae. Fannie Mae began as a government agency and has now become a privately owned corporation. Fannie Mae is currently traded on the New York Stock Exchange. So remember that Fannie Mae raises monies by selling stocks and bonds to its investors. This money raised is used to buy and sell conventional loans, along with government-backed notes. Then we have the Government National Mortgage Association, otherwise known as Ginnie Mae. Ginnie Mae is still a government agency and is a part of HUD, the Housing and Urban Development. Finally, we have the Federal Home Loan Mortgage Corporation, Freddie Mac. This is a government corporation that issues preferred stock to the public. It is supervised by the Federal Home Loan Bank Board. Freddie Mac helps savings banks maintain a stable and adequate money supply by purchasing their home loan mortgages and repackaging them for sale to investors. The savings banks use the money obtained to make new loans available to home buyers. Now to finish up, I'd like to give you some glossary terms. First, we have conventional loans. These are loans sold to the secondary market, and they have a lower loan-to-value ratios, which offer a greater protection for the lender. Compared to FHA loans, conventional loans are riskier. The higher the risk, the higher the interest rate. We've made our way to Section 5, the transfer of property. The Department of Real Estate's testing emphasis on this topic for salesperson and brokers is 10%. Though not heavily tested, some of the concepts in this section need to be thoroughly understood. Let's begin with escrows in general. Now, an escrow is the processing of the paperwork and money involved in a sale or other real estate transaction. Now, the purpose of an escrow is to meet the terms of the contract. Now, you want to remember here that escrow is a neutral third party and their purpose is to meet the terms of the contract. Escrow will only proceed when all the agreed conditions have been performed. You may be asked, what are the requirements for a valid escrow? First, you need signed escrow instructions. This forms a binding contract between two or more parties. This is usually buyer and seller. Next, you need a neutral party, which is the escrow company. This company acts as a dual agent for the buyer and the seller. Then you need conditional delivery of funds and documents when all the conditions in the escrow are met. During the escrow period, the escrow company acts as a dual agent. When the escrow closes, this changes to a separate agency. The escrow company now handles each party's separate paperwork requirements. A neutral third party, or an escrow officer, can be one of the following: a corporation, an attorney, or a real estate broker who also acts as the real estate agent in the transaction. And this is something that you definitely want to remember, that a broker can handle escrows for a fee only if that broker is acting as a real estate agent in the transaction. Let's move on to see how escrow works. Now, the first step in a real estate transaction would be to select an escrow company and an escrow officer. Now, these are part of the negotiations between the buyer and seller, just like any other item in a real estate transaction. If an escrow company is named in a listing agreement between the seller and the seller's agent, there cannot be a change in the escrow company without consent. Now, it is imperative that the salesperson disclose in writing any interest that they may have with that selected escrow company. Remember, a real estate licensee is prohibited by law from receiving any kickbacks for the solicitation of an escrow business. So let's move on to some escrow rules. Once the escrow instructions have been drawn from the original contract and then signed by each party, neither party can change those instructions without the knowledge or consent of the other. Now, an escrow is complete when all the conditions of the escrow have been met, all the conditions of the parties have been met, and the parties have received an accounting of the procedure. If both parties mutually agree, instructions can be changed and put into effect at any time. If the parties cannot agree to the terms, an escrow company will settle the dispute by bringing in an interpleader action. This is a court action. This is to determine where the money in consideration would go. Note that the seller cannot rescind, in other words, cancel the escrow without the consent of the buyer. When both parties signed escrow instructions, those instructions take precedence over the initial purchase contract. The escrow instructions then become an enforceable contract binding on all parties. In real estate transactions, most agents are looking forward to the closing of escrow. Closing is the date of recording. The process of closing, in a broad sense, is the process of signing, the transfer of documents, and the distribution of funds. Now, when time is not specified, the escrow will close by mutual consent or within a reasonable period of time. The closing date is the date that the documents are recorded. The escrow company usually approximates the closing date, but the actual date is when all of the conditions of the escrow have been completed and the buyer's remaining money is received, and all the documents are then recorded. Another task involved in an escrow is proration. This is the process of proportionately dividing the expenses or incomes to the precise date in which escrow closes. Property taxes, interest, fire insurance, and rents are prorated, but not title insurance fees or non-recurring fees. All escrow companies use a 30-day base for which results in 360-day year. This is called an escrow or bank year. Property tax prorations are based on the amount of tax the seller is paying. Escrow uses the old assessed value when prorating. When prorating property tax, the amount of the tax the seller is paying is considered the base. The escrow uses the old assessed valuation when prorating. When prorating an item, the two dates that are most important are the date that the escrow closes and the date that the item was paid. Let's move on to other things that escrow is involved in. One thing that is a condition of the escrow is a structural pest control report. California law requires that the seller must receive a copy of the pest control certificate before the close of escrow. The best time for a seller to have a termite report issued is before putting the home on the market. Now, what is a structural pest control report? Well, this is a report given by a licensed pest company identifying any wood-destroying pests or conditions likely to cause pest infestation. This report states the condition and the correction cost of any pest, dry rot, excessive moisture, earth-wood contacts, fungus damage in the accessible area of the structure. The report states the condition and the correction cost of any pest-related damage in the accessible area of a structure. Another item handled by the escrow company is fire insurance. This is a must when a lending institution is involved. Another type of insurance is title insurance. A title insurance company is primarily concerned with what is called the chain of title. This is a search of the public record. It gives a public history of the conveyances and encumbrances affecting the title as far back as the records are available. The product of this search is the abstract of title. This is the written summary of a property's documents that evidence the title. The title insurance serves four functions. It insures a lender and the property owner for an additional fee against the loss that result from the imperfections in title. The title insurance also ensures the marketability of the title to the property. Title insurance is paid only once, unlike auto and fire insurance. The first step for an escrow officer is to order a preliminary title report. This report shows the condition of the title before a sale or a loan transaction. The preliminary title report gives the current status of the items that affect the property's title. This is normally from the county records. Now, all title insurance policies in California cover policyholders as of the date of the policy. Now I'd like to move into the topics of the types of title insurance policies. This is the topic where most people will miss questions in the exam. Title insurance policies are paid through escrow. Now let's look at the types of title insurance policies. All title insurance policies in California cover policyholders as of the date of the policy. First, we have the standard coverage policy, also known as the CLTA policy. This policy may be issued to insure a lender only or an owner only, or it also may be issued to insure both. This policy protects against the lack of capacity of a party in a chain of title, deeds not properly delivered, and forgery. Now, most lenders require more protection than provided by a standard coverage policy. They require what is considered an extended coverage policy, the ALTA, also known as the lender's ALTA. What a lender's ALTA policy does is provide a survey of the land. Make sure you clearly understand what are not covered in the standard CLTA policy and which are included in the ALTA policy. Note that the CLTA policy does not include an on-site inspection or survey. Therefore, there are certain items that are not included in that standard policy, which will be included in the ALTA policy. Now, to receive more protection, one would purchase an extended coverage policy which includes a survey. This is called the ALTA policy. This policy gives only the lender the extended protection. If an owner wants this kind of protection, they would request the extended ALTA owner's policy. You may ask, who pays title insurance fees? The title insurance fees are a part of the escrow closing cost. And because no law determines who must pay, it should be stated in the purchase contract to prevent any misunderstandings. This, however, only covers the standard coverage policy. The additional cost of the ALTA extended policy is usually charged to the party purchasing the property. The additional cost of the ALTA extended policy is usually charged to the buyer. Quickly, I'd like to review the Real Estate Settlement Procedures Act, also known as RESPA. RESPA provides borrowers the opportunity to shop for settlement services. This law covers first loans on 1 to 4 unit residential dwellings, including FHA and VA loans. The law states that the settlement statement must be delivered on or before the date of settlement at no charge. The buyer can request this 1 business day before closing. Now we're going to look at how real property is acquired and transferred. There are 7 basic ways to transfer real property. We have deed, will, probate, in-state succession, where there is no will, accession, occupancy, and dedication. We're first going to look at transfer by deed, which is the most important. The deed is not the title, but it is the evidence of the title. Now you want to note that all deeds must have a granting clause, an action clause. Now there are two basic types of deeds, the grant deed and the quitclaim. All other deeds are versions of these two deeds. Now a grant deed is the document that transfers title with the keyword being grant. The granting is the aspect of the deed that is a promise that A, the owner has not conveyed title to the property to any other person, that the property is free of any encumbrances other than those already disclosed to the grantee, and that the grant deed also transfers any after acquired title, meaning that the rights obtained after the sale have been completely conveyed. A grant deed comes with implied warranties. These are not expressed in writing, but implies that the owner has not conveyed title to another and that the property is free of any encumbrances. Now remember, a grant deed does not necessarily give someone all the rights to a property. There still may be easements, rights of ways, mineral rights and building restrictions, and other types of restrictions that still restrict the use of the property. A quitclaim deed is a deed that conveys only the present rights or interests that a person may have in the property. A quitclaim deed makes no covenants, basically no promises. They guarantee nothing and only convey all the rights that the grantor may have. A quitclaim deed can give absolute ownership or only as much title as one may hold. If there is no ownership interest, then nothing can be acquired. Note that there are no warranties, just the clause, I quit claim. This deed is used primarily to clear a cloud on the title from the record. Now what is a cloud on title? This is a claim or an encumbrance or a condition that has impaired the title to real property. Now until disproved or eliminated, as with, for example, through the use of a quitclaim deed, or a quiet title legal action. An example is if a buyer purchases a property on an installment plan and abandons that property after a few payments. Then there would likely be a cloud on the title, if the contract was recorded. Remember that all deeds must have a granting type clause. This is an action clause. A valid deed passes title when the deed is recorded, thereby giving constructive notice. A valid deed has the following essential elements. It must be in writing. The parties must properly be named and have legal capacity, and the property must be adequately described. There also must be that granting clause, and it must be signed by the granting party, the grantor. You might also be tested on the delivery of a deed. Delivery and acceptance of a deed is presumed with the recording. Here are three basic methods of delivery. The manual delivery, a direct transfer of the deed from the grantor to the grantee. A delivery through recording, putting the title of record in the grantee's name at the county recorder's office. Obviously, the grantee must have agreed to the recording. Then there is the conditional delivery. Requires that a specific event take place before the title can be passed and must be handled by a third party. The deed then becomes delivered manually. Now we have the transfer by will, or testate. A will is a document created by a person stating how that person's property is to be conveyed or distributed upon his death. There are two types of wills that legally can dispose of real and personal property. These are the witnessed, this is a typed, and a holographic, a handwritten. A witness will is a typed document usually prepared by an attorney. It's dated and signed by the property owner and is declared to be a will by at least two witnesses. A holographic will is entirely handwritten by the owner and is dated and signed. Since it is in the owner's own handwriting, no other formalities and no witnesses are required unless the will is signed with an X, in which case it must be witnessed. Now we have the transfer by probate. This is done by superior court procedure to determine a will's validity and to determine any creditor claims. This also establishes the identity of any beneficiaries. A transfer by in-state succession, no will, is the procedure used for transferring the deceased's property to his or her heirs if there is no will. With in-state succession, the law provides for the disposition of the property. We have separate property. If the descendant leaves a spouse and one child, the property is divided equally, 50-50. If there is a surviving spouse and 2 or more children, 1/3 goes to the spouse and the 2/3 go to the children. If there is no surviving spouse, the property is divided equally among the children. What if there is no will and there are no heirs? The property then reverts to the state of California. This is not automatic. It must be initiated through legal proceedings. This is called escheat. Remember, individuals do not acquire property by escheat. Now we have transfer of property by accession. Natural causes. Accession occurs when an owner acquires title to additional land by natural causes. That is, addition to the property by improvements or natural growth. Terms you definitely want to know here are accretion. This is the addition to land from natural causes such as earthquakes or volcanoes, or action of moving water. For example, a river over time will slowly deposit soil on one of its banks. These deposits of soil are called alluvium. Avulsion is the sudden, violent tearing away of land. The title to that land is lost by the property owner. Then we have encroachment, the placement of improvements and permanent fixtures on property that do not legally belong to the person who placed them. Permanent fixtures attached to the land or building by resident tenants must be left with the building. Any improvements that are mistakenly placed on the property must also remain. Now we have the transfer by occupation. Ownership of real property or the use of real property can be gained through 3 types of occupancy. We have abandonment, adverse possession, and prescription. Let's look at abandonment. This is the process of acquiring property that someone has abandoned. One cannot acquire title to abandoned property without court action, but a landlord can acquire possession of property that is abandoned by a tenant simply by gaining full control of the property. How about adverse possession? This is acquiring title to another person's property through continuous and notorious occupancy for 5 years under the claim of title. It is the legal way to acquire title without a deed. Title may be obtained through adverse possession only as long as certain conditions are met. There must be open and notorious occupancy. It must be hostile and adverse. It must be uninterrupted use for 5 years, and there must be a claim of the title. And finally, property taxes must be paid. The adverse possessor must have paid all the tax levied and assessed on that property for the 5 continuous years. Note that adverse possession is not possible against public or government land, but only against privately owned land. Now, a quiet title action is brought in the court to prove that all 5 requirements have been fulfilled. And the third way to transfer title by occupancy is through prescription. This is an easement or the right to use another's land, which can be obtained through 5 years of continuous use. Its requirements are similar to those of adverse possession, but the differences being, by prescription, only the use of the property is obtained, and by prescription, taxes are still paid by the initial property owner. Remember, prescription is the use of a property, not the transfer of its title. Now we have the transfer by dedication. Obviously, a dedication is the gift of land. One can dedicate or gift the land for some public use. To be fully dedicated, the land must be accepted for such use by authorized public officials. Dedication may either be voluntary or mandated by statute. Now, the final process of transferring property is recording and acknowledgement. The recording is the legal process of making an instrument an official part of the records of a county after it has been acknowledged. Instruments that affect real property are legal documents such as deeds, mortgages, trust deeds, leases, and contracts of sale. Recording gives constructive notice of the existence and content of these instruments. To understand constructive notice, this is any recorded notice that can be obtained through the county recorder's office. Any document recorded with the county recorder is assumed to be public knowledge. Actual notice is knowing or one's responsibility for knowing that a transaction has taken place. As an example, if you had noticed that there were tenants in a home that you were looking to buy, you should have been aware of the possible existence of a signed lease. This is actual notice, whereas public records are representative of constructive notice. The act of taking possession gives actual notice. Know that the recording process is a privilege rather than a legal requirement. Some documents have to be recorded to be valid. As we talked about before, the mechanic's lien or the declaration of a homestead. You may record an acknowledged instrument at any time. However, failure to utilize the privilege of recording at the earliest possible date can result in a question of legal and rightful title. If the same property is sold to more than one party, the individual who had recorded first will usually be recognized as the rightful owner. Therefore, the time of recording is very important to a bona fide purchaser, who is protected only if he or she records first. Now, if there are no prior arrangements, the deed having priority is the one recorded. In order to establish priority, the documents affecting real property must be recorded by the county recorder in the county where the property is located. If the property is located in 2 counties, it should be recorded in both counties. Let's look for a moment at the priority of recording. Under the recording system in California, the first in time is the first in right. If an owner sells his or her house twice, the first deed recorded is the valid deed. Remember, there are 4 exceptions to the rule that protects a person from later recordings. They are government liens and property taxes, actual and constructive notice, mechanics liens, and agreements to the contrary. And we're going to finish up this section with acknowledgments, or notary. All documents must be acknowledged before they are recorded by the county recorder. This acknowledgment must be performed in the presence of a witness, usually a notary public, authorized by law to witness acknowledgments. Remember once again that a deed does not have to be acknowledged to be valid, but it must be acknowledged to be recorded. This concludes Section 5, the transfer of property. In Section 6, we're going to cover contracts. The Department of Real Estate's testing emphasis on this topic for salesperson and brokers exams is 22%. Let's dive into some general information about contracts. Now, to define a contract, it is an agreement to perform or not to perform a certain act or service. Now, every contract consists of a promise or a set of promises that are enforceable by the law. Now, these promises may be created in 2 ways, either in an expressed manner or in an implied manner. An express contract is an agreement that's either made orally or in writing. Listings and deposit receipts and leases are all express contracts, whereas in the implied contract is created when an agreement is made by acts and conducts, implication, rather than by word. Implied contracts are not used in the practice of real estate. A contract may either be bilateral with 2 promises or unilateral, 1 promise. Let's look at bilateral contracts. This is a promise made by one party in exchange for the promise of another party. It is in essence a promise for a promise. A unilateral contract is where only one party makes a promise for the act of another. This is a promise for an act. 2 types of unilateral contracts that you'd like to know for your state exam is the option contract and the open listing contract. Remember earlier when I mentioned a lease option, this would be a unilateral contract. And the other unilateral contract, the open listing, makes the promise for the act of another. The seller promises to pay a commission for the act of the agent finding a buyer or selling the property. So a unilateral contract is a promise for an act. So in the open listing, if the agent sells the property, the seller is now obligated to complete their promise and pay the commission. Contracts may also be classified in any of these four different ways. A contract may be valid, voidable, void, or unenforceable. Now, a valid contract is a fully operative contract that is binding and enforceable in a court of law. Performance is expected, or legal action can be filed. A voidable contract can be affirmed or rejected at the option of a party. A victim can rescind, cancel, or annul. A voidable contract remains binding until it is rescinded. A void contract is that contract which has no legal effect. In essence, it does not exist. It lacks one of the essential elements of a contract. Note that a contract for an illegal purpose is considered void. Now, an unenforceable contract is a valid contract that for some reason cannot be enforced in a court. For example, a law that has been changed can make a performance illegal. Now let's look at the life of a contract. The contract has basically three separate phases. The first phase would be the negotiation period. The buyer and seller discusses the possibility of a contract. If there's mutual interest between the parties, then an offer, perhaps several offers, can be made. The offer becomes a contract when accepted, provided that all the other elements necessary for the creation of a contract are present. To execute a contract means to sign a contract. Now, phase 2 of a contract is the performance. An executory contract is a legal agreement with provisions of which have yet to be completely fulfilled. An exclusive listing agreement just signed by an owner is an example of an expressed, bilateral, executory contract. The listing is express because it is in writing. It is bilateral because a promise has been made by one party in exchange for the promise of another party. And it is executory because the provisions of that contract have yet to be completed. A home has yet to be sold. The final stage of the contract is the completion. It is the executed contract. And the terms for this phase of the contract would be the executed contract. This is that contract that has either been discharged or performed. And then there is the execution of a contract. This is the act of performing or carrying out the contract. Now note, a contract to be performed is called executory. A completely performed contract has been executed. The contract lives on until the legal right to bring legal action has expired. This is called the statute of limitation. Now let's look into the elements of a contract. Note here that money, the way a contract is written, and the performance of a contract are not essential elements of a valid contract. The four essential elements of any contract would be the capacity, mutual consent, the legality, and the consideration. Now, if it involves real estate, there is a fifth element, and that is proper writing. Let's look at capacity. Now, for a contract to be valid, there must be two or more parties, and those parties must have the legal capacity to establish a contract. Minors, those who are incompetent by law, and convicts are unable to establish a contract. A minor is someone that is under the age of 18. There's also the term emancipated minor. This is someone who has the contractual rights of an adult. Note that minors and incompetents may acquire real property by gift or inheritance. Convicts have basically lost their civil rights during imprisonment. They may acquire property by gift and inheritance or by will, but they cannot convey the property. The second element of a contract is mutual consent. Consent must be genuine and free from fraud or mistake, and there must be a true intention to be obligated, or it may be voidable by one or both of the parties. Note here that death does not cancel most contracts. They are binding on the estate, except a listing agreement, which is an employment personal service contract. Now, a buyer can withdraw his or her offer at any time prior to receiving communication in writing of its acceptance and receive full refund of the money deposited. An offer is defined as a person's willingness to enter into a contract. Every offer must have what is called contractual intent. This exists when a party communicates an offer to another with the intention of forming a binding contract. In real estate, a condition must often be met before a contract becomes binding. If the condition is not satisfied, there is no contractual intent and no binding agreement. Something to note here is that an illusory contract appears to be a contract, but it is enforceable because it is not definite and certain. The second element of a contract is acceptance. If an offer is accepted, it is a legally binding contract. Should the buyer now die, there is still a legally binding contract. When there is an offer, it can either be accepted or there can be a counteroffer. The counteroffer is the rejection of the original offer and the proposal of a new offer with different terms. Once there is a counteroffer, the previous offer is automatically rejected. To terminate an offer, there are 6 ways that this can be done. There can be a lapse of time, a revocation of an offer. This is where the person withdraws their original offer. There may be a failure of the offeree to fulfill a condition. There may be rejection. The offer is just simply rejected or it is terminated. Or there is death or insanity of the offerer or offeree. And once again to stress, this is only before an offer has been accepted. And then finally there's the legality of purpose. If the condition or the purpose of the contract are illegal, then the contract is then automatically terminated. Now, the final requirement for mutual consent is that the offer and acceptance must be real and genuine. If not, the contract is void or voidable by the victim. Genuine consent does not exist if any of the following conditions are present: fraud, misrepresentation, mistake, duress. This is unlawful detention of a person or that person's property. Menace, a threat or a threat to commit duress. Or it can also be a threat of unlawful violent injury to a person. And finally, undue influence. This occurs when a person in a position of authority, such as a person in a confidential relationship, uses that authority to an unfair advantage. This moves us to the third element of a contract, is legality. A contract must be legal in its formation and operation. Both the consideration and its objective must also be lawful. So basically, a contract that forces one to break the law is void. The final element of a valid contract is consideration. Consideration is anything of value. In a contract, anything of value may be given by one party to another to make the agreement binding. A valid contract must have sufficient consideration, which is the amount of consideration a judge would hold necessary to support a contract. In real estate transactions, normally a consideration would be 1% of the purchase price. That amount would be given with the offer. Now, with real estate transaction, there is a fifth element, which is proper writing. A listing agreement must be in writing to enforce the payment of a commission. Oral agreements between brokers to share commissions are binding. Now, personal property contracts, such as a rental agreement for 1 year or less, need not be in writing. And any contract that can't be performed within a year from the date of signing must be in writing. Some terms I'd like you to know in regards to contracts would be assignment. This is the transfer of a person's right in a contract to another party. Novation. This replaces an old contract with a new contract. Discharge of a contract. This occurs when the contract has been terminated. And breach of a contract. This is non-performance. The most common breaches from an agent's point of view are the buyers who decide not to buy after signing the deposit receipt, or the sellers who decide not to sell after signing the listing or deposit receipt. And in regards to breach of contract, we have the statute of limitations. This is the established time limit for suing a party in civil action. And in regards to breach contracts, let's look at remedies for the breach of a contract. By law, the party who has been wronged has only 4 choices. First, there is the acceptance of the breach. Basically, the wrong party does not pursue legal action. A unilateral rescission is where the wronged party discloses the wrong and the breaching party restores everything of value to the offended party. A third course of action is for dollar damages. This occurs when the wronged party requests payment as compensation. In a real estate transaction, a liquidated damages agreement is used and is set in advance a specific amount of money as a penalty if there is a breach. This clause is used because it is usually impractical or difficult to determine the actual damages caused by a breach. The current award for liquidated damages on a deposit receipt form is a maximum of 3% by law of the home purchase price. Any deposit amount in excess of 3% must be refunded to the offeror. And the final remedy for a breach of contract is specific performance. This means that the party causing the breach is forced to perform to the terms of the contract, and this is done by court order. An example is a court may order that the offeror complete the purchase transaction, or that the seller continue to sell the property. Now I'm going to go over some details of the deposit receipt or purchase contract. There is the offer and acceptance. The deposit of money or items of value must accompany a purchase contract or deposit receipt to be a valid offer. If a